complaint to the state. Well, the next news you know, Susan Barker started getting bad performance evaluations. She wasn't getting invited to meetings, and pretty soon they basically drove her out of there. So she sued them for retaliation. The district court said, well, you know, she's not a disabled person, so too bad. She doesn't have standing. It's not her problem. But the Ninth Circuit looked at the language, which was very clear in the regulations. If you are connected to a disabled person, if you're advocating for a disabled person, you could be a parent, you could be a teacher, you could be anybody in the world, and if they retaliate against you, then they are on the hook for money damages for doing that. So after that decision, Riverside County Office of Education and Susan Barker settled up. So that's a very strong protection for teachers and school staff that want to advocate for students and are being told by their principals, I don't want you to see these kids, which happens a lot. Some of the examples that we've had of retaliation, one of the funny ones, we had an IP meeting in Chino, actually, and they were insisting on assigning written essays as makeups in a PE class, which is against the law to do with any kid. They're supposed to actually give physical education in PE. But they were insisting that they should do this, and the teacher was furious because she wanted to be able to assign these things. We were saying, you're not going to do that. And so, anyway, we broke down the law to them, and she had to give up. She had to say, well, okay, but we won't assign it. We won't assign the essay. But she was so furious about this that she ran out of the room, and 10 minutes later she started yelling at the kid and calling her names. That's retaliation. So we were able to use that. In the end, her attorney was able to use that to pry a little more out of him in a settlement agreement. Another one that we had, the kid had been in junior high school, not in her regular junior high school. So all of her peers were going to go with her to another high school down the road. And for no good reason, because this parent has advocated for her kids and stuff and taken them to due process about 3-4 times. They said, no, she's going to have to go to a regular home high school and she's not going to get to go with all the other kids. And they were doing this just saying, because we can. So in that case, we filed for a 504 due process hearing. We didn't bother with IDEA because we didn't want to get into an argument about least restrictive environment and blah, 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 and IDEA. We just filed for a 504 due process hearing saying they were retaliating against the kid and they were endangering her because she really needed peer support. She had fetal alcohol syndrome and things like that. She really needed support of peers in school, and they were depriving her of this. So she was 102nd in line for the inter-district transfer thing, but somehow they found a place for her in the other high school. So then we would do the complaint. So that was very helpful. That was an easy solution to something that could have been a very difficult problem. Then we had another one where they simply didn't want to, they were mad at the woman for pushing back and advocating for her kid. They had their own ideas. So they wanted to put this kid in a county class. It was a 25-minute ride. But really, when you put him on a bus, it was more like an hour. So it was just going to destroy his whole community life because he was going to get home late. He had to leave early and stuff. So we filed for a 504 hearing on that issue, and they gave up. And then they tried to put him in another place, and then but that was, since they'd already said that the place they now wanted to put him in wasn't suitable, that wasn't very easy to defend. So they gave up, and they gave him what he wanted, and he's doing very well. And now they're happy with him. It turned out that the district saved money by doing what they were supposed to do instead of what they were trying to do. So many times you'll have a thing that's going to be very difficult if you try to handle it under IDEA, but if you handle it under 504, it's very easy to fix. Now, one very common form of retaliation, and sometimes they don't think of it this way, is they'll tell you, well, you have an IEP. So because you have an IEP, you're really not entitled to 504 protections anymore. What they're telling you is, you don't have a right to the same civil rights as other people because you're using an IEP. That's not true. That you have an IEP doesn't take away the rights that you have under 504 at all. They owe you all that stuff. Many times they'll say that because they don't understand it. Now, the third point I guess I want to cover is some differences between 504 and the ADA. They do kind of look the same. IDEA has an IEP, 504 has a 504 plan. IDEA has the very detailed procedural safeguards which we can use to our advantage. And 504 also has procedural safeguards in a lot less detail, but they still have them. IDEA provides for due process hearings with the state, and 504 provides for due process hearings with the district. So they look a lot the same. And so they will tell you the 504 is sort of a junior version of IDEA. But it's not true. It's as I was saying here, embarazada does not mean embarrassed. They kind of look the same, but they're really not the same. I can say in English that I am an advocate, but I can't say, yo soy abogado. I'm not a lawyer. So they are, in fact, quite different because they're different sorts of laws. Under IDEA, the IEP basically tells you what you get. You work it out in an IEP meeting. The parent is supposed to be a very important participant. You're supposed to come up with this document, and this document says this is what we need to do for this kid. And if it's not in the IEP, they don't owe it. Under 504, the district doesn't even have to produce a 504 plan. But if they do produce a 504 plan, they don't have to involve the parent in producing it. A lot of times they do, but they don't have to. However, the difference is the 504 plan is not a document that governs what you get. The 504 plan says, this is what we plan to do to obey the law. But what they plan to do and what the law says isn't necessarily the same thing. They can say, well, it's not in the 504 plan, but if it's in the law, they got to do it anyway. Which is a very important difference, which means that you can keep going to the law and the regulations and you don't have to concern yourselves with what's in the 504 plan necessarily. Of course, if they tell you it's in the 504 plan, it's hard for them to turn around and say we don't owe it. But if it's not in the 504 plan, maybe they owe it anyway. Now, under IDEA, there are 13 different conditions that qualify you to be covered under IDEA. And you look at the kid, you assess the kid. Well, does the kid meet one of these things? And if he does, then you qualify him under IDEA. And it's all a matter of assessment and discussion and debate with the school district. And maybe you qualify, maybe you don't. Maybe you go to a hearing to argue about it if you have to. Under 504, you qualify if you have a disability, if you look like you have a disability, if people think that you have a disability even though you don't, and they treat you that you have a disability, if you have a doctor's note saying that you have a disability, it's pretty hard for them to say that you don't have a disability. So it's much easier to qualify in that way. It is designed to be written so that you don't get into a dispute about educational things. So then also, IDEA doesn't have any explicit protection against retaliation. It does in a way, because if they retaliate against you, if they intimidate you, if they do different things to stop you from being involved in the process, then they're denying parent participation, and so they are denying FAPE. So there's sort of a protection against retaliation in IDEA, but it's indirect. What happens is that you end up denying FAPE if you retaliate. Under 504, there's very strong protection, and there's also money damages available, which you can win in court. And the definition I gave on the earlier page is the one that the Office for Civil Rights uses. So this means that you're very well protected in many cases. You file a complaint, you refuse different services or whatever. If they turn around and try to hurt you, then they run into that. A situation we run into is in California, you are allowed to cafeteria shop the district's offer. Okay, you've offered these different things. I'm taking that, I'm taking this, I'm taking the other thing, but I don't want that. and I don't want this other thing, and this other thing over here, I don't want that either. You can do that. And if the district doesn't like it, they have to go to a due process hearing and prove that the stuff that you don't want, you need. And so what they'll do instead, maybe, is they'll say, well, we're just not going to give you the other things, which they're not allowed to say. Or maybe they'll file a truancy notice against you. Any of that kind of stuff is retaliation under Section 504. And we have stopped that kind of behavior on a number of occasions in that way. So you have very strong protection that way in the way of retaliation. And you can keep them from misbehaving. And you can therefore protect your kid. Now, these other pages I don't want to go over in detail, but I just want to let you know you're here. There is the 504, I printed off the 504 definition of disability from the education regulations, which you'll want to look at, and also the FAPE definition, which reads as, for the purpose of this subpart, the provision of an appropriate education is the provision of regular or special education and related aids and services that are designed to meet individual educational needs of handicapped persons as adequately as the needs of non-handicapped persons are met.
Oops, I'm sorry.
Whoa!
I need a mommy. She's not in here?
Oh, hi there. Oh, I am ugly, I know that.
No, okay. Wrong room. Thank you, I'm sorry.
I think mom just left. Mom was sitting there.
So, and I also have some links in here. We did have the thing was sort of done, it was stapled together out of order. But anyway, the links are also here. I gave links and stuff for the Office for Civil Rights in San Francisco, both for the state and also for Health and Human Services, for Education for Health and Human Services. I saw a very nice federal website called Limited English Proficiency Federal Interagency Website, www.lep.gov, which takes you to various useful places. I also put here a few instructions on how to find things and my contact information. And Advocate's contact information. You're free to email me, you can call me if you want, and you can certainly go to our website. And on the whole, we serve people for free. Occasionally we get donations, but on the whole, we serve people for free, so we can help with questions and like that. And so here we are, and I will entertain questions. If there are any questions or comments or experiences or anything, I'd be delighted to go into that. Talk.
What if a child is ADHD, she's going through school and she's getting decent grades. One of the things in her 504 plan is that the teacher will not single her out,
Okay.
but yet she continues to put her name on the board to single her out because of her ADHD.
Okay. Well, first off, and it doesn't even matter what's in the 504 plan. They are singling her out and discriminating against her. If a black kid went in there and they kept talking about his nappy head, everybody would see that there's a problem with that. And when they're talking about her ADHD, they ought to see that there's a problem with that. And so it is absolutely illegal for her to act in this way. It's also possibly retaliation. If they're doing this to her because they want to hurt her because they're mad at the kid, or if they're mad at you, either way, it's retaliation. So you can take it, first it looks nicer if you, and it's of course more just and merciful if you give the district a chance to fix it. So have you talked to the principal?
No.
I would start with that. Because you've talked to the teacher, because otherwise you wouldn't be talking to us. So you've talked to the teacher, I guess now you talk to the principal, and you put it in writing that you talk to the principal, because if it's not in writing, it never happened. So you put it in writing that you had this conversation and this is what you agree. Either the principal puts a stop to it or he doesn't. the principal is personally liable for damage.